Welcome everyone to day 3 of Washington Arbitration Week. It's November 30th, 2022, and we're here at ICSID in Washington, DC. And we have a couple items on the agenda today, which we'll get to. But I first wanted to thank ICSID for hosting this event today. It's always great to be here. It's been a long time since we've been able to get together, and it's really great seeing so many faces that haven't seen in a long time. So welcome, great to see you. Also wanted to mention the co-organizers of this event, ICSID LLP and Dr. Jose Antonio Rivas and his team, Anna and Maria Lucia and the whole ICSID group. They're the ones who've been sending out all the emails and keeping track of us all and making the trains run on time. So just wanted to mention that there's been a huge effort to coordinate I think our 20 some odd panels this week at I think 5-6 law firms have been hosting. We've just had a great upswell of support this year, and this is the 3rd edition. And I just wanted to mention that, you know, this sort of the roots of actually Washington Arbitration Week has been in the COVID pandemic. It was really kind of seen as a solution to, you know, trying to get people back together and trying to bring together the Washington arbitration community. And it's really amazing how people have come together, worked and put together so many great panels like the one we're going to see today. Really, Washington is a fantastic center for international arbitration, for commercial arbitration, of course. We have great courts here, we have great facilities, and of course, ICSID is the jewel in the arbitration crown of Washington. And we're very happy to be here and talking about all things ICSID. So before we have a panel, an ICSID panel, which is coming up in about 20 minutes, a half hour. But before that, we have our honored keynote speaker for Washington Arbitration Week. We like to, at least, you know, after 3 editions, I don't think we have that much of a tradition, but one of our traditions is we're trying to do a kind of a midweek keynote speaker. And we have the great pleasure today of having the Secretary General of ICSID, Meg Kinnard, speak to us on, I'm sure, something related to ICSID, but we'll see. It's always a surprise. But you know, I've known Meg for, I don't know, some 25 years now, having worked together on opposite sides in some of the earliest NAFTA cases, which some of you may know from at least the students from your LLM classes. It's now seemingly history. But you know, the one great thing about the international arbitration world, we work opposite each other. We work hard on our cases to win or lose, but we're all colleagues together. And it's great working with you, Meg, and certainly with everyone here who I've worked with and opposite. The same sentiment applies. But you know, Meg has had a fantastic career. She was Director General at the Trade Law Division at Canada's Foreign Affairs Department, working on WTO cases and NAFTA cases, as I said. And then she made the big move to Washington here and has done a fantastic job at ICSID. And we want to, I think, all indicate our gratitude and thanks for her efforts over the many years in developing ICSID into the great institution that it is. And on that note, I wanted to introduce and ask Meg to come up here and give some keynote remarks. Thanks, Meg.
Thank you very much, Ian. I have mixed feelings about being called part of history, I have to say. Still working with that one. But what I want to talk about today is a little bit of ICSID history, a lot about ICSID present, and a little bit about the future. But we have an amazing panel in particular that's going to delve into the future. So I welcome you to the center and to our beautiful facilities. I think we moved in here about 8 months before the pandemic or something well-timed like that. So some of you may not have seen them. So please, after the session, feel free to grab an ICSID staff member and have them tour you around. We are very proud of our facilities, and they are wonderful places to have hearings and conferences like this. So we welcome you today. The topic we have of ICSID past, present, and future obviously is especially relevant as we come to year end and we think about the milestones that we've achieved in the last year, but also as we start thinking about what's next and what are we going to be doing in 2023. I think the success of ICSID and its growth in the past 55 years is rooted in particular in some of the design features of the ICSID convention. And the more I look at this, the more I find things that were very prescient features to think in sort of 1965, 66, drafting this document and thinking of things like conciliation and enforcement and all of the things that we find grounded in the ICSID convention is actually a real tribute to those who were the drafters of it. I see two design features that I think are especially important and have really been relevant to keeping the organization on a steady ground. The first one is obviously that the drafters decided to create a facility and a set of rules for dispute resolution, but they did not veer into the substance of substantive obligation. And this obviously was a very smart design choice, especially when you put it in the context of the treaties that have come up, in particular since the 1990s, mid 1990s, and the desire we've seen for states to actually be the masters of defining the substantive obligations in their treaties. So I think it was a stroke of brilliance to basically offer ICSID as the facility for dispute resolution, but not get into that evolving debate about what is expropriation or national treatment or any of those issues. States clearly want autonomy in that respect. The second key design feature that I would look at is the inclusion of the simplified enforcement mechanism. And that, of course, is unique to ICSID and distinguishes it from every other option for investor-state dispute settlement. And we know that facility users see this simplified enforcement mechanism as absolutely vital, and rightly so, because an unfulfilled award obviously does very little to resolve an individual dispute or to enhance confidence in the investment climate of any country or in its rule of law commitments. So those were, to me, the two key design features that really defined ICSID and brought us to a very strong place to start from and helped us move through the last 55 years. I'd also want to pay a tribute and a note to the foresight of the leadership that ICSID has had in the past. We all know, and it's especially important to note the work of the first Secretary General, Aaron Brockus, who steered the convention through the negotiation process, who developed the first set of rules and really led the center in its formative days. If you look at that history of the ICSID convention, you will see the kinds of discussions that were held and some really ingenious ways that he was able to find consensus and to move the whole project forward. It's also important to note the third Secretary General, Mr. Ibrahim Shihata, who was in office from 1983 to 2000. I still remember my first days at ICSID where I would say, well, why do we do it this way? And I would not infrequently get, because Mr. Shihata told us to. Mr. Shihata started that. And I sometimes felt like the ghosts of Mr. Shihata were in the halls and I had huge shoes to fill, literally and figuratively. But he was an incredible formative influence on the ICSID convention and on the center. He also had some very important roles, for example, chairing the task force that led to the very famous World Bank Group guidelines on the treatment of foreign direct investment. And he increased ICSID membership to 132 states. So all of his work is still very much evident today. I'd also like to note the debt of gratitude we have to Antonio Pera, who we're very lucky to have joining us today. Antonio was clearly the heart of ICSID for over 15 years, and he successfully steered the organization through some of the very challenging years, including those where there were a number of cases with respect to Argentine financial measures. Some of the first NAFTA cases were coming up, and most notably steering the what ultimately became the 2006 amendments. So I think ICSID has been extremely lucky to have some really dedicated and very, very capable leaders, and that's been a lot of the key to its success. To go to the present, we are today 158 members strong, with another 7 states who have signed but not yet ratified. And I look back in the last about 14 years, we've had on average about 1 new state join per year, which I think is an amazing statistic. We hear so much about states running from investor state. the facts are, once again, that there is growth every year, steady growth and commitment to this system. Over the years, we have become the premier investment facility, and we have done over 70% of all known investor state cases. So there is a real center of expertise here. We offer, I think, top-notch service, and we offer that everywhere in the world. So you see, we have our hearing rooms here in Washington. We have hearing rooms in Paris, currently under a little bit of construction, but they will be back. We have facilities cooperation with over 30 institutions. And if we need to, we can hold hearings or sessions in more than 120 World Bank offices around the world. So I really am confident that there is no single place in the world where ICSID could not hold a hearing if the parties requested a hearing in that location. In addition, as we all know, the pandemic has forced us, in a way this perhaps is a silver lining of the pandemic, but it has forced us to pivot to remote hearings, and we offer parties unrivaled service through electronic means. We've done more than 500 remote sessions over the last 2.5 years, and you get really good when you do that 500 or more times. What we are seeing is that parties are actually more frequently requesting now what we're calling hybrid hearings. The idea that you will have a core group of your counsel team and your arbitrators in one location physically, but then also be able to broadcast to a larger part of the group that is working on the case. And I suspect that that will be a growing trend in the future, and again, is one that we are more than happy to accommodate. We have also increased in terms of cases, and I think everybody has seen our wonderful ICSID statistics in the charts, but it again is remarkable when you put it in context. By the early 1990s, ICSID administered an average of 2 cases per year, and that's not really that long ago. We are now administering and receiving roughly 55 new cases every year, and at any one time, we are managing 375 to 380 pending cases. So this continues to be an increasingly busy place. We've also grown from a staff of very few counsel, who originally were actually shared with the legal group of the World Bank, to a secretariat of 72 people who are solely dedicated to the ICSID role. And I see a number of our colleagues here, and for those of you who've worked with them, you will know that they are not only dedicated, but also an expert group. We have modernized our administrative systems, and I think these are some of the things that you don't necessarily see first off, but they're important to the overall quality of the undertaking. So we have modernized our administrative systems. We've got fully remote filing by parties, so no more bankers' boxes, thank goodness. We have case management technology that's very useful, and we're all using that in-house and for each case. And we have fully digitalized our financial systems. So that really helps to ensure the service is well managed and transparent. Since 2017, and this again is something perhaps that most people don't recognize, but since 2017, ICSID has been financially self-sustaining. And we are very proud that we have been able to do that while maintaining our administrative fees at an extremely reasonable level, and also without asking for contributions from member states. So there's been a lot going on sort of underneath, basically, at the same time as the things that you see when you open up the website first and foremost. We have also taken on a large role in technical assistance, and I think you will know that there's probably an endless need for technical assistance, and the more you can do, the better it is. So we've contributed quite a lot to technical assistance in the last roughly 10 years. We've done that in part through publications, and in particular, we've got the ICSID Review, which now is issued 3 times a year by Oxford Publications. But we've also added what I think in the bank parlance would be called a knowledge product. Basically, we have a number of documents. For example, the background paper on annulment. We have the Respondent's Guide to Case Management, and we have our ICSID statistics that get updated every 6 months. All of this, I think, is helpful in terms of technical assistance and what to expect, but also very important in that if there is going to be a dialogue on investment arbitration and investment treaties, which there evidently is, it is really important to start it with an empirical basis. what are the facts, and to launch the discussion from there. So these kinds of products are really important to that kind of basis for a discussion. Our technical assistance has also taken the form of multiple training courses and reference materials, both for government officials and for private sector counsel. So you may well have seen, for example, some of our presentations on how to mediate an investor-state dispute, how to prevent disputes in the first place, how to manage a dispute if it actually starts. And some of you may also have even been to our, what we used to call ICSID 101 course, which was actually a great course. We haven't done it in a little while, but it was a great course to start people from day one, the request for arbitration, and work all the way through to compliance and enforcement. So that's the kind of commitment we've made to technical assistance. We have also made huge strides in terms of the diversity of tribunal members and ad hoc members, and that's been done through a number of efforts. First of all, we have spoken to our member states to encourage that they keep their panel lists up to date, and have explained to them the kinds of criteria you would look for in someone who is on the list of arbitrators or the list of conciliators. And I think if you see how many designations have been made in the last few years, you will see that states are rising to that challenge. So we now have a list that has more than 700 people on it, and it is more diverse than ever before. In-house, we have also been offering parties various techniques for selecting arbitrators. There is, if parties want the usual, I think, strike and rank list, which we all know, but we have also come up with and offered something that we call a ballot, which essentially is giving parties perhaps 5, 7, 9 options and allowing them to say whether they would accept that person, and allowing them, if they both agree, to select that person. And all of these really go to trying to complement the ability of the parties to select their tribunal. We recognize that that is an extremely valued feature of arbitration. And so our efforts are, to the extent possible, for parties to be able to come to that selection between themselves. This kind of rank and strike and ballot also has a secondary purpose in that it complements the efforts to bring new people into this milieu. Again, recent statistics will bear this out. In about 2009, we saw how many females were arbitrators, and the number was under 9%. And I think most of them were Gabrielle Kaufman-Kohler and Brigitte Stern. So it was a very, very small number. We've made a huge effort to address this. And so, for example, in fiscal year 21, we had 31% female arbitrators. In fiscal year 22, we had 24% female arbitrators. And I'm proud to say that of those appointed by ICSID, 45% were female arbitrators. So the world has really been changing in this way and continues to change, and we continue to support that. We are also trying, as we consider trying to get the milieu more diverse in terms of gender, also looking at other things. A key one is regional origin and diversifying the pool of arbitrators by regional origin. And the other one, which you may not think of as often, is something you might call a first-time flyer. In other words, replenishment of the arbitral pool, new people coming into the field and being able to do this work. So, for example, last year, 11% of the appointments involved individuals appointed for the very first time. And of those, 45% were women and 25% involved nationals of low or middle income economies. So we have very much dedicated ourselves to trying to address diversity. And I know that private sector and parties, state parties involved in this have also become very much aware of the importance of diversifying the arbitral group. I think perhaps the most important legacy of ICSID to date has been its leadership role in modernizing investment dispute settlement at large. And in this respect, of course, I think about the amendments of 2006, which truly were pioneering. These staked out transparency of proceedings for the very first time and brought into the mainstream things like non-disputing party submissions, open hearings, publicly available awards, and excerpts of those awards. The 2006 amendments also brought the manifest lack of legal merit motion, basically something that you might think of as an early strikeout motion in domestic procedure. And these have now become not only widely accepted in ICSID practice, but widely emulated in other sets of rules that address investor state. So it has now become how we operate in this discipline. In 2006, you may remember, there was also a proposal for an appellate body to be hosted by ICSID. And we do know that it was not accepted by member states at the time, but there is a wonderful paper still on the ICSID website. And I think in many respects, Antonio Para authored it and did a wonderful job, but it clearly would preserve the advantages of the ICSID system were states to go to an appellate body mechanism. And we know states are considering this at Working Group 3. And I mention it because I think it is still a very useful reference in respect of that kind of a direction. In the past year, we got to the ICSID, what we're calling ICSID 2022, basically the second set of amendments. And these ended up being the most comprehensive amendments we have ever done. And I think it was done through the most transparent process we have ever had. I'm very proud to say, first of all, that it is done, that it was adopted, but more importantly, it was adopted by an 85% approval rate of members and not a single rejection. And I take that as an important statistic, not just because it exceeded what we required to adopt these new rules, but I see it as a very strong endorsement of the new rules and further evidence that they have addressed the procedural concerns that we had heard in all the various debates leading up to these ICSID 2022 rules. They have set the future direction for investor state, and I think not just for ICSID. In particular, there is an increase, quite a large increase in transparency that I think can have a very concrete impact as cases come under the new rules. There's the potential for expedited arbitration and a number of techniques to deal with the ever-present concern about time and cost. There is updated conciliation. There is significantly expanded jurisdiction under the additional facility, which I think is something that a lot of people haven't noted, perhaps because rightfully you're exhausted after you've read the first tranche on the convention, but the additional facility is a lot more available now under the ICSID 2022 rules. And most importantly, a set of standalone mediation rules. And we know there's a lot of enthusiasm among claimants and respondents to be able to mediate disputes. And they now have the framework to do so under the ICSID system. So I think cumulatively, these are definitely going to strengthen investment dispute resolution. The big question, obviously, and I'm going to in particular probably leave that to my learned colleagues, but the big question is what can we expect for the future? We all know that some commentators have urged states to walk away from investment arbitration and investment agreements. And we know some have, but I think it's important to remember that most have not. And I certainly feel that the prevalent mood is not to abandon this discipline, and that most states and investors are interested in strengthening it and, frankly, getting on with business. What states and citizens realize is that the cost of unresolved grievances is absolutely immense, resulting in losses of billions of dollars a year. And of course, nobody likes a dispute, but there is something worse, and that is an unresolved dispute. And in the investment context, the unresolved dispute leads to investments abandoned or investments never even made in the first place. So we're going to continue our work with our stakeholders to make this the most effective and efficient dispute resolution system. So we will continue to leverage technology, obviously. We're going to continue to encourage dispute prevention and hands-on management of disputes. We're going to continue to offer a variety of dispute resolution techniques. And our number one job right now, we are going to be implementing these new rules, which I think you will see lead to some very concrete changes. So we're pretty excited about the future of ICSID. I would like to move then to our panel, and we have a number of questions for them. It is a tremendous panel that we've pulled together today, and let me first introduce our panel members. We have, first of all, Marin Carlson, who is a co-leader of the Global Arbitration trade, and advocacy practice at Sidley's here in Washington, D.C., and a very experienced counsel in investor-state dispute matters. We have Susan Frank at the far end, who is a professor at Washington College of Law at American University. You will know Susan, who's published various articles and books on international law and dispute resolution, and she is one of the foremost experts in using data and statistics to study dispute resolution. We have as well here in person Jose Antonio Rivas, who is a founding partner of XStrategy, a well-known counsel in investment and commercial matters, and as Ian said, one of the co-founders of Washington Arbitration Week, which is a tremendous thing. So we congratulate you. This has been a great addition to the Washington arbitration scene. We are also joined today by Don McCrae, who is an emeritus professor from University of Ottawa Faculty of Law, an expert in public international law. He's sat numerous times, and I'm hoping we've got Don. There we go. Hi, Don. An expert in public international law. Don has sat numerous times as an investor-state dispute settlement arbitrator and as a panelist in free trade agreements and at the WTO. So he has very broad in public international experience. And I guess for any of us who are Canadian, I don't think there's a one of us who hasn't been educated by Don, and we thank him hugely for that. We also have Antonio Parra with us. And as I said earlier, Antonio is a former legal counsel and DSG at ICSID. He was here from 1984 to 2005 and has been a huge source of inspiration and great advice ever since, and has done a number of contributions to the discipline, but in particular, 2 editions of the history of ICSID. So Antonio is a font of knowledge about ICSID, and we're so delighted that he is joining us today. So what I would like to do, if I may, is move to our question and answer part. And what we have is a number of questions, and we thought that we would have our panelists address these questions in pairs. And we're happy to have any kind of questions from the audience as we go along. And we'll try and look to a lot of the issues that are arising now. So there's a broad range of items that we thought we'd cover in this Q&A type session with our panelists. So I want to start, keeping with our past, present, and future theme, start with something about the past. And the question here is, what were the most important strategic decisions made in designing the ICSID system and drafting the convention? And I think there's no better person to start us off here than Antonio. So Antonio, I will pass the microphone to you.
Sorry about that. Can you hear me now?
We can. It's perfect.
Yes.
We hear you and see you.
Sorry. And thanks to Jose Antonio for organizing this event, and to Meg for moderating the panel, and of course for her introductory remarks. In answer to the question that Meg has just posed, I would start by saying that different people have at different times had different ideas as to what were the most important strategic decisions in designing the ICSID system and drafting the ICSID convention. For example, Aaron Brockes wrote his Hague lectures on ICSID in 1972, amid rising instances of agreements between governments and foreign investors containing arbitration clauses being frustrated as a result of unilateral action by the government terminating the agreement, including its arbitration clause. Brockes referred to this experience when, in his Hague lectures, he termed as, quote, probably the most important provision, end quote, of the ICSID Convention, its stipulation in Article 25, that once both parties have given their consent to the jurisdiction of ICSID, neither may withdraw its consent unilaterally. For Brockus, the provision had the effect of, quote, elevating to the level of an international legal obligation, end quote, the ICSID consent clause concluded by the parties. Ibrahim Shihata, to take another example, published his well-known article on the roles of ICSID and MIGA and the depoliticization of investment disputes in 1986 in the first issue of the ICSID Review. The article, originally composed for a Latin American audience, was written against the backdrop of a prolonged debt crisis in Latin America. Shihata's conclusion in the article was that ICSID and MIGA represented what he called modern responses, enabling developing countries to attract more foreign direct investment in place of loans from commercial banks, all while avoiding the politicization of investment disputes and the espousal by foreign states of claims of their nationals. In the section of the article on ICSID, Shihata emphasized as key to the achievement of what he saw as, quote, ICSID's fundamental objective to depoliticize the resolution of investment disputes, end quote. The provision of Article 27 of the ICSID Convention prohibiting a contracting state from giving diplomatic protection or bringing an international claim in respect of a dispute that one of its nationals and another contracting state had consented to submit to ICSID. Given today's immense and still growing network of international investment agreements, or IIAs, my own candidate for a provision of the ICSID Convention reflecting a most important strategic decision in its design and drafting would be the provision of Article 25 as to a form of the consent of the parties to the jurisdiction of ICSID. Under Article 25, this need only be expressed in writing and need not, in particular, be recorded in a single instrument. As we all know, the resulting flexibility has allowed ICSID jurisdiction to be founded by investors accepting offers of consent in the investor-state dispute settlement provisions of many of the approximately 2,500 IIAs now in existence. According to the most recent edition of the ICSID caseload statistics, almost 80% of all ICSID cases are cases of this kind. Some see this as anomalous, arguing that the ICSID Convention was intended only to cover contract disputes. I cannot, however, find much, or indeed any support for this in the drafting history of the ICSID Convention. At the earliest of the meetings of the executive directors of the World Bank, who had formal responsibility for drafting the ICSID Convention, at the earliest of their meetings on the convention, it was predicted that ICSID, predicted by one of the participants, an alternate executive director from Iran, it so happens, he predicted in this discussion that ICSID, quote, might in practice have a great deal of business, end quote, in part because, quote, many governments might insert ICSID clauses in their commercial treaties, end quote. The earliest IIAs concluded from the late 1950s to the late 1960s had provisions on the settlement of disputes. However, these provisions, only address disputes between the states parties to the treaties. Aaron Brockes noted this in his address as Secretary General of ICSID to the first annual meeting of the Administrative Council of ICSID in 1967, a little less than a year after the ICSID convention came into force. In his remarks, Brockes said that now that the ICSID convention procedures were available, it might be advisable, quote, to substitute these procedures for those provided in the treaties, end quote. 2 years later, in 1969, ICSID issued a set of model ICSID clauses for investment treaties. The same year, 1969, saw the conclusion of the first IIAs incorporating such consent provisions, now commonplace, of course, in the IIAs that have proliferated in subsequent years. Thanks a lot.
Thanks, Antonio. Susan, what would you point to as a strategic decision that set the direction for ICSID?
Well, I think part of what I want to frame this conversation about is it's very important to remember the past, because we live in a modern reality where TikTok and Twitter tries to tell us how to live and remember the information about how to think critically about the state and future of investment dispute settlement. And so I'd like to kind of have us dial back a bit from that kind of cognitive fast thinking and instead make sure that we're reframing where we actually have been. And I actually think, Antonio, is so wonderful to be here. And I was obsessed with your book this summer, of course, and did a deep dive into the Travaux myself. And there was so much that I both relearned and also learned for the first time. So I would flag Meg's own observation of what was the words you used, not to veer into the substance of international investment law, but instead to create procedural mechanisms that are ex ante agreed to. So the better angels of our nature can help us resolve conflict in a meaningful way, rather than having to worry about the substance that can and should and must be the prerogative of sovereign states. Now, that having been said, in terms of learning from our past so that we can understand our future, I very much think Antonio has again put his finger on the nub of things. If you look at the drafting history, developing states were very active and had strong voices. It's not just the Iranian delegate. It was people from India. It was people from China that were making absolutely, I would say, almost snarky comments, but at the same time, delightful. There were so many things that were on the record that I wish I personally could have been a fly on the wall to watch how Brockes managed these political situations to get people to focus on procedure rather than substance. So for my money, although Article 25 is a very important design choice and was, of course, the focus of much debate, for my money, it's actually Article 42, which is where all the money is, namely the applicable law provision that tells you what is the substance that governs the dispute, which is not within the hands of ICSID at all. And again, that drafting history is quite good, with Brockes saying, hey, states, if you don't want to be bound by this international law, don't include it. Do something else. If you want it to be the treaty law, go for it, multiply, be happy. I'm paraphrasing here. But at the same time, he also said, if you wish to exclude it and pick a state law, a state contract law, a state law on foreign investment, you have the capacity and the freedom to do that. And he was very much inviting states to exercise sovereignty, especially because so many of the developing states were coming out of colonialism, experimenting with their own ideas of what international law should be and minimum standards of treatments for foreigners. And there's just lovely language that is in the record that kind of points that out. And I do have actually an article that's going to be coming out next year in the Michigan Journal of International Law, where I kind of do my Frank's deep dive into the Travaux, so you can get my take on history that is based on data. But I wanted to give you one last bit of data before I cede the floor and shut up. Namely, remember the ICSID convention was in force and ratified in 1966. So there is this wonderful publication by UNCTAD that talks about all the bilateral investment treaties in effect before 2000. Well, I have done a kind of a deep culling of that, and I found a couple of things. Number one, in 1969, like 3 years after ratification, over 130 countries and territories had no bilateral or multilateral investment treaty in effect. Right. So think about that. If there's like 190 plus countries and territories in the world, we had more than 130 that said no, like no soup for you. That was not what they were up to. However, and this was again 1969 is when I looked at it, there were less than 60 treaties in force and effect. Just put that into your brain and let it seep in terms of the substantive law that could be the legitimate province of a dispute at ICSID. And this explains why Brokus went on the record, not just because of the observations of the Iranian delegate, which Antonio was quite right to point to. He said, I predict 90 to 95%, and he doubled down on 95% again, that these cases will be resolved by domestic national law that states control rather than treaties. And I think we have to remember that in terms of the flip that has happened, but we need to remember that history, but because he said 95%, not 100, right? It means treaties could have a role. We can't forget that, but it was not the original genesis. So let's remember our history, and that history is actually quite rich.
Thank you, Susan. I wanted to move on to the present and some of the themes that we hear. And one of the big themes we've heard in discussion has been that there is a lack of predictability or coherence of case outcomes. And the question I have is whether this critique is one that actually has been outstripped by what has happened. In particular, we have a lot of new treaties that prescribe what the law is. We have new rules. And most importantly, we have a body of case law that has really provided a lot more predictability as it evolves over time. So the question I want to put first to Professor McCrae and then to Jose is, do you think this mantra, lack of predictability or lack of coherence, is still really a valid one, or has the world evolved beyond that critique? And maybe we'll start with Professor McCrae.
Thank you very much, Meg. Thank you.
Thanks, Don.
Can you hear me?
We absolutely can.
We can hear you, but actually I can't see him.
I can see myself on the screen, but I'm not sure that helps.
You're here with us. Thank you.
Is that fine? Can I proceed?
Please do.
Okay, I think the starting point in thinking about predictability and coherence is what is it that states are saying about that? And I think in the UNCTAD working group sessions on ISDS reform, you found a variety of views. Some saw predictability and coherence in terms of arguments being made before tribunals, even though those arguments have been rejected by other tribunals. Others saw it as a problem of governments not knowing how treaties will be interpreted. Then some spoke of predictability as and coherence as a systemic problem, and others thought the problems were really not about the system, but arose out of who were appointed as arbitrators. And others said that predictability and coherence weren't really desirable in a system of single instance treaties. And differences in treaty interpretation can reflect differences in the treaties themselves or the context in which they're concluded. And others said that consistency in treaty interpretation is not the same as accuracy in treaty interpretation. I think when considering what states are saying about that, you have to consider a couple of background factors. And one relates to expectations. And I think the expectations of investors and the expectation of states in respect of what investment agreements could provide haven't always been the same. I think that investors probably saw ISDS as protection for their investments that would operate like a domestic court system, an insurance against the actions of governments that might harm them. And I think states, on the other hand, tended to see investment protections as guarding against something more narrower, reprehensible treatment of investments, appropriation, other outrageous behavior in the treatment of investments. And I think we saw this played out in the earlier cases where governments sought to have a much more restrictive interpretation placed on matters such as fair and equitable treatment. And I think that the variation was this, that developed countries or capital exporting countries didn't really see investment treaties as readily applying to their own behavior. Their so-called advanced legal systems would already have the protections that were provided for under investment agreements. And I think under NAFTA, it turned out this wasn't true, that it wasn't just Mexico that was the recipient of investor claims. And we see the same sort of reaction, I think, in Europe to some extent, particularly in the context of the Energy Charter Treaty. The other point I think we have to consider as background is that at the outset, decision makers on investment tribunals were largely arbitrators schooled in commercial arbitration. And that's where there was a substantial body of expertise in conducting arbitrations, dealing with procedural questions, and the complex claims to damages. But as far as the substantive law of investment treaties is concerned, it generally involves treaty interpretation and sometimes the articulation of customary international law. And I think these were things that were comparatively new for commercial arbitrators. I think we see evidence of this in Jan Paulsen's groundbreaking article, Arbitration Without Privity, which was an attempt to answer the question, what is this new thing we're dealing with? Investment arbitration, I think we also see in the early cases, arbitrators attempting to give content and apply the Vienna Convention on the Law of Treaties. What we had was those trained in one discipline, so to speak, learning the language and practices of another discipline. And we see this in the debates over the MFN clause. We see it in the jurisprudence that treats the power to recommend provisional measures as a power to order binding provisional measures. Debates that are about the scope and ambit of the interpretive process in dealing with a treaty regime. And these differences of interpretation have contributed to the view that ISDS law is not predictable or coherent. But I think you have to look more broadly. There's a variety of factors that affect predictability and coherence. The fact that decisions are made by ad hoc tribunals with different compositions will inevitably mean that views and interpretations will differ, and predictability will be harder to achieve. But that's inherent in the nature of the system. But in general terms, I would say that investment jurisprudence has reached a certain level of predictability and coherence. In any case before an investment tribunal, one will find arguments that follow a similar pattern, cases cited that are familiar, arguments that point in similar directions, and to a certain extent, decisions of tribunals analyze the law in similar ways. Now, this is not to suggest that outcomes won't be not necessarily predictable, because they often are fact-based and represent a fundamental differences in, rather than representing a fundamental difference in law. And I think nor is it to say that there will not be decisions that will generally be regarded by subsequent tribunals or states as fundamentally misconceived, but that happens in any system of adjudication. And of course, in investment arbitration, there's no ready way to repair this. But of course, as governments redraft their investment treaties to limit or expand them according to their interest, the scope of arbitral decision-making may be narrowed or curtailed. Unclear provisions may become clearer. And as ICSID revises its rules, as Meg has pointed out, to accommodate change and improve them, again, areas of contention are being clarified. But in all cases, interpretation is still required, and with further opportunities in interpretation for disagreement. As a final word, I'd like to say that I think that the major controversies over ISDS have not been so much about predictability or coherence. They're about whether ISDS should be there at all. The Argentina debt crisis, the current concerns about energy litigation in Europe are not about the coherence of the system. True, one can disagree with different tribunals on how broadly they're interpreting certain provisions, and this debate continues, for example, with respect to fair and equitable treatment. But the concerns that are expressed reflect the fact that states are finding that the extent of the disciplines under these treaties go further than they had appreciated. And that's something that can only be resolved through treaty revision, not by saying that investment decision-making can be made more predictable or that the system lacks coherence. Thank you.
Thank you, Don. Jose.
Thank you, Meg. Concerning predictability, I would say I would start simply by asking whether this is really a desired characteristic, or it's simply a characteristic that we may not see out of the ISDS system. When we have, as we all know, more than 3,300 investment treaties, to aspire to a system where one issue will be treated by a different tribunal under a different treaty in the same manner is very aspirational, and I'm not entirely sure that it's the right aspiration. That being said, predictability, yes, perhaps under the four corners of the applicable treaty, that we can aspire to. There are many aspects that make the aspiration of predictability perhaps a wrong one within the system, or one that we might not be able to grasp. And I say this because this is in connection to some of the discussions at the Ancestral Group 3, where the notion of or the promised land is being set too high of a bar by thinking that there must be consistency. Again, we're not under the WTO law where there's a set of treaties for all members. We are in a different system. Plus, as things are going, we see every day more new generations of treaties. We now are seeing the possibility of at least dual or fragmented dispute resolution system. On the one hand, the existing arbitration system, and on the other hand, a multilateral investment court system. And that might get the aspiration way too high. That being said, and I am an optimist. That being said, I do believe that the system has matured in an incredible manner, and there are some areas in which, because the system is now more than 50 years old, what we can see is areas in which there have been significant progress, and I would even dare saying that there is in some areas majority or some type of jurisprudence constante, where you could see issues that have been resolved that within the ICSID system had not been resolved in the first year. So to be very specific, let's think in terms of could a province act in breach of an investment treaty, and that of course for those who have sort of a public international law DNA is an obvious question. You look into Article 4 of the Articles on State Responsibility, and you say yes, of course. But the system itself had to, the ISDS system itself had to deal with that issue in some of the early Argentinian cases. And then nowadays, I would say that nobody would ask that question. It is already, I would dare saying, jurisprudence constante. If a Canadian province or an Australian state or Argentinian province act in breach of international law, that is attributable to the state. And there are other areas like this. Another example that we could give, at the early days at ICSID, we had a discussion on whether indirect investments could be a subject of claims by minority investors. That issue is also one that I would say, unless there is clarity to the contrary within the treaty, would be part of jurisprudence constante. So my message is yes, it takes a long time for a 50 years old is the age of, or a little bit more than 50 years old is the age of the ICSID system. It is predictable to the extent, or the ISDS system, to the extent that you can expect a legal system to be predictable within 50 years. And in comparison, think about the Roman law system. So I will stop at that.
I can't help but jump in because you're giving me flashbacks. The very first brief that I wrote as an associate in an investment treaty case, I spent about 45 pages explaining why consent did not have to be in the same document, and it was okay that it was in a treaty on the one hand and a request for arbitration in the other. And nobody would even put a footnote down for that today, right? Exactly. So I exactly agree that sort of the predictability or coherence question would look very different if you were asking that question in 1998, or even 2005 than it does in 2022.
That's exactly it. Maureen, I wanted to start with you on the perennial question of time and cost in investor-state dispute settlement. Are we going to be able to cure this, or at least make it a lot better? And how can councils and tribunal and the institution try to attack this problem and succeed?
Thanks, Meg. Well, I mean, I think the first thing that we have to recognize and look forward to are the innovations that are in the 2022 rules. And a lot of time and effort in the development of the rule amendments was dedicated to this question of how are we going to improve efficiency, and how are we going to be cost sensitive in the process? And that's not, I mean, set aside the simple innovation of the hybrid hearing, the Zoom hearing, the fact that we do our first sessions by phone or by Zoom, and e-file everything, and we don't kill the trees. Claudia Fritos-Peterson was here, and I was thinking about one of the first filings I did where we were literally like handing over large boxes, but stacks of them, like 15 boxes, and trying to shuttle those across Washington in cabs, and it was terrible. So thank God for that's all gone. So innovations of the 2022 rules. Obviously, we've got the biggest innovation of all, I think, is the set of expedited arbitration rules that can be selected and applied. Sort of the entirety of Chapter 7 is in the rules, and the thought there is actually to potentially reduce the time of the arbitration by as much as 50%, to default to sole arbitrators, so that we can, for the appropriate proceedings, move these things forward faster, and in a more streamlined fashion, so that it's not only the mega disputes that can be resolved in this system. Then we look at things like mandatory case management conferences, not just the first session where we all set the aspirational rules that are going to govern us for the next 2 or 3 or 4 years, but actually case management conferences in which the tribunal is encouraged and reassured that it's fine to narrow down the rules, narrow down the issues, to identify uncontested facts, to shape the proceedings in a way that will make them more efficient. And I look forward to that happening, particularly in connection with document production. We can only hope. Then we've got, throughout the 2022 rules, time limits where time limits did not exist before, both time limits on the parties to get them to act quickly, and also time limits or aspirations for the tribunal to set expectations about how quickly the tribunal may act. And whether that's, on thing, the range runs from applications to disqualify arbitrators, to the issuance of procedural order number 1, to applications for bifurcation, and then on the far end decision making, how quickly we'll get decisions in a manifest lack of legal merit proceeding, or on an award or in a rectification or an annulment context. Also, clarifications about bifurcation requests and about the manifest lack of legal merit process, so that parties understand how those will operate, and set their expectations accordingly. There's also a few sticks, right, to keep us in mind. More direction, more power for the tribunal when it comes to the allocation of costs, including interim cost allocations. And publicity about costs. There may be moments during the arbitration where it's hard to think ahead to the day when someday somebody's going to see how much we spent on X. But maybe that's a discipline in its own right, particularly when my pet peeve of document production. But I think the overarching importance of this issue is illustrated in the fact that right there up front in Rule 3, at the very beginning, we have the general duty of all the parties to the proceeding, not only, of course, to act in good faith, as we always expect, but to act with an eye to efficiency and cost effectiveness. And that's where I think the rules can only take us so far. And I think when it comes to time and when it comes to cost, we have to acknowledge that we have seen the enemy and they are us, right? The rules can't fix everything for us. We have to be better disciplined ourselves, whether we're sitting in the council chair, whether we're sitting in the tribunal's chair. For council, heaven forfend, we should perhaps talk about page limits. Now, okay, we have to talk about them in advance because nobody can halfway through a proceeding and say, oh, I'm going to confine myself to this many pages. But maybe if we could actually have that discussion ahead of time, we could actually do better at narrowing down the issues and focusing our attention on what really matters, instead of being worried that if we don't talk about every single thing, that someday someone will fault us for that. And then when it comes to the tribunal, that same motivation, right? That's that same concern of I have to talk about everything so that nobody can say that I didn't talk about it. So that I've already alluded to document production, right? Should document production really be a multi-million-dollar exercise in these cases? How much actually comes out of document production that actually changes the face of the proceedings, that actually potentially changes the outcome of the case? As counsel for more than 20 years now, I can really think of very, very few instances where first of all, I've never seen the darn smoking gun. Sure wish it would show up someday. But even the thing, I can literally put on one hand the number of times that I've seen a document come out of document production that had a meaningful impact on the case. And so, we need to constrain ourselves. Now that's always easy to say in advance, very hard to say in the thick of the adversarial process. But we can't expect the rules to do everything for us. And so we're going to have to be better behaved as well.
Thank you. That's great. Susan, what are your thoughts?
Well, I'd like to provide a little bit of a historic frame as well. So in Antonio's book, he's got wonderful pictures of the drafting history of the ICSID convention. There's actually only 2 women pictured in the entire book, believe it or not. One is Meg, and one is a stenographer busy taking notes. And I believe it's on page 93 of his second edition, if you want to have a look at that. But the reason I bring this up in connection with cost is there were actually 2 women participating in the conversations. One was a Ms. Brunn representing certain Nordic countries, who I never figured out who those were. But Ms. Villa-Geratner from Austria actually had a major role in the debate and discussions of the evolution of how costs are treated in the ICSID convention. So it's one of those places that you can point to a conversation between her and actually the Brazilian delegate that made a difference in terms of what we actually do today. Now, mind you, the convention punted. And now we have, thank you, Meg, finally, some rules that actually provide much more information about cost shifting. So I'm very grateful to the founding mothers of ICSID who decided to take the issues of cost seriously. So I want to ground that conversation first. In terms of time and cost, as some of you may know, I have a small obsession with this issue and wrote literally the book on it in 2019. But I think what's important to remember from that book is the single most important variable that was linked to any type of cost. Claimant cost of lawyers, respondent cost of lawyers, tribunal cost was always time, the number of months it took to have a case. And I want to remind people of the really quite excellent work that ICSID did in connection with the rule drafting. I think you guys did the only good study I ever saw on bifurcation and impact on time and case management. I mean, that is brilliant, and it's a hidden gem within the record. So please do feel free to look at that if you're thinking about how do I worry about cost containment. So I very much appreciate what Marin said with the case management conferences. And I actually am so pleased, Meg, that you went from having a permissive CMC to a mandatory case management conference, because this is about nudging behavior to prevent due process paranoia from creeping into the proceedings, such that we are so worried about process that we forget what we're actually trying to achieve here is international rule of law. So I think that is going to be a very useful innovation. And I think that is exactly the time to talk about page limits, but the scope of what might be happening with experts, because those are the things that can contain costs and minimize the amount of time. And let's just be blunt about it, the number of bodies in a room who need to be able to manage their diaries over the next 3 to 4 years. So I think that is a wonderful innovation in terms of time and cost. But I also want to kind of flag a couple of things that I think are interesting. And part of this comes from a book chapter that I've got coming out with Bailey Rowe, who's an associate at Arnold & Porter and a happy, proud Washington College of Law alum. But we talked about the ICSID rules in particular and the cost and time elements. One thing that I think is actually quite useful, and this goes back to part of Marin's comments, so often there already was a legal opportunity to do things with cost management, interim cost award earlier. There was always that doctrinal and theoretical possibility, but for whatever reason, cognitively, we let it slip to the side. So what the ICSID rules are doing functionally is they're creating a nudge. This is a Cass-Sunstein nudge moment where it's an opportunity to force us to think about things we haven't done before. So in terms of the factors that ICSID now requires tribunals to consider when thinking about cost shifting. And keep in mind, like, I think we all know that we're talking around $10 to $15 million worth of cost. This is not a small amount, and indeed arguably larger than some substantive claims. If they're doing that, we need to have some rule of law factors. And ICSID very helpfully codified a series of factors that are actually the most typically used by tribunals. And the book I actually had has a content analysis on that. So you can actually go and see, what did ICSID do? What did the data show? And there's actually a really nice match. But I want to also suggest that there was a trick that was missed. So, and Meg, you know, this is my longstanding critique. One of the things that did not get put in as a factor to consider in connection with cost shifting was party settlement efforts and efforts to negotiate or mediate a dispute over the course of the lifetime of that dispute. Some of the early cases did talk about that, but it's not something that made its way into the rules. So to the extent Frauke is here, one of our leaders of the mediation efforts. And I know Don McCrae, who's on the screen, is also interested in mediation. The fact that we're not tying those together in the cost shifting expressly means we've lost an opportunity to nudge that behavior, but we still have the capacity, because it's like other factors that could potentially be considered. But the whole idea is nudge, 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 because when people get to the cost side at the end of the dispute, everybody's exhausted, cognitively depleted, and we can't forget those things while we're managing earlier parts of the dispute.
Thanks, Susan. Those things might be considered in conduct of the parties, so we'll see what tribunals do. There's still a nudge there. I want to move to transparency. We all know that the Mauritius Convention was very ambitious in terms of transparency, but to date, only 9 states have ratified that convention. We have now some very ambitious transparency goals in our new rules. And the question is, can the ICSID 2022 rules have a more concrete and immediate effect on transparency? Jose, maybe you can start us off.
Thank you, Meg. Absolutely. There's one component to transparency, and of course the question is, whether the ICSID rules may have not only within the ICSID system but beyond a spillover effect. Before referring to the technical question, I'd like to say that transparency goes hand in hand, at least in my view, with the issue of legitimacy. There's many modifications, and I'll refer to the ICSID rules, the new ICSID rules modifications, articles 62 to 68, plus the requirement of disclosure for arbitrators under Rule 19. But one of the reasons why there's a strong predictability of saying yes to the question is one, we are referring to ICSID and many, perhaps most of but I think that it's worth noting that ICSID still does, at least and perhaps more, 70% of investor state arbitration cases. So it's a very straightforward question. If you have that portfolio of cases, yes, transparency requirements will be implemented. But beyond that, there's also the issue of legitimacy, and I think I would like to follow the words that you shared during the keynote speech in terms of 85% of the states were in favor of the rules. There was no opposition, and that leads to a conversation of yes, application of the rules because they're legitimate. And on the legitimacy issue, doing a little bit of research that is available to everyone, 67 countries provided comments, and many of them provided comments in each one of the rounds of working papers. Some of them, 4 or 5 times, and that is a very, very rich and participatory process. In some conferences, I can think, for instance, in the about UNCLOS, the UNCLOS convention, and I don't want to segregate it, any other area of international law. I don't think that in other areas of international law you would see that participatory process where you could see countries of each continent providing comments. In addition to that, I know that there was a very significant process in terms of capacity building, because it's not only about providing comments, but also understanding what others are saying. And during the 4 or 5 year process that the rules amendments took, I understand that there was a lot of knowledge sharing, and that makes the possibility of implementing the rules, including the transparency rules, much higher. Now, going into what those rules are, I will simply say that there are key factors, including the possibility of now publishing the awards, unless the parties, either party to the dispute, expresses its dissent within a specific time. In addition to that, there's also the provisions that specify that there'll be publication of all orders and decisions not terminating an ICSID arbitration proceeding. That's Rule 63, and the list goes on. In terms of actual change, I believe that these rules make a huge difference in terms of hearings as well, and because now the rule is not to ask for permission, but actually there must be the other way around. There must be an opposition to having the public hearings, and of course, publicity and transparency is always in tension with the issue of confidentiality. But what's so interesting about the rules is that even that tension is supplemented by a framework as to how to determine a result, of course, by the tribunal, between transparency and confidentiality. And last but not least, and this is at least in my understanding, an influence of NAFTA and similar treaties, FTAs with investment chapters, there is now an expansion within the rules to the participation of non-disputing parties, which I believe is something that clearly creates more comfort to states. There might be second thoughts by investors themselves or counsel for investors in terms of why do we need this, but the reality is that these are rules that are namely talked and discussed by states. So in general terms, I think that one, legitimacy, the actual power of the provider, ICSID in this case, And three, the spillover effect. We have seen in investment treaty arbitration that some doctrines that start in the ICSID history make it to the disputes solved under the Swedish Chamber of Commerce. And one example of that is the Salini test. And I'm not saying that I'm in favor of that practice or not. I'm simply noting that that happens. How some of the rules that are decided within the rules here in the amendments, but also in jurisprudential lines, some of those have a spillover effect in international law and in ISDS. And that I see as something very easily happening also concerning the transparency provisions, way beyond the Mauritius Convention.
I mean, I really like the transparency rules. I also have to give lots of credit to ICSID for essentially going as far as you can in publication within the bounds of the convention, right? I mean, the one place where we're absolutely stuck is that the convention says you can't publish without the consent of the parties, but you took it as far as you could possibly get it within those strict constraints. And so I think, you know, the overarching theme of the transparency provisions in the 2022 rules is that presumption of publication, that presumption of transparency in all aspects of the proceedings. And there will be circumstances in which, you know, the hearing is not going to be open, or when it's going to be on a limited basis that it'll be open, or there will be redactions from the awards, or there will be redactions from procedural orders. I mean, but just to establish a presumption that procedural orders should always be published, that's an innovation in and of itself, right? It's in some of the new treaties, but it's not necessarily sort of the instinctive reaction of parties with 20 years of experience in investment treaty arbitration. So I do think we talked before about nudging. Well, this is definitely a place where there is nudging going on, and a little more shoving, actually, not just nudging. And thinking about the practicalities of how this is going to be implemented, I mean, I hope that in 1 or 2 years, the process of redacting decisions, awards, orders, and everything else is going to be as second nature to us as counsel as the process of making transcript corrections, right? It's just going to be the thing you do automatically after you file. Walk through your document, figure out what needs to be redacted, have a little bit of a discussion about it with the other party, and then move on. Right now, it's still sort of this kind of black box, who knows what should be redacted and what shouldn't, and how much we'll have to argue about it. So I also really like Rule 66, which gives us a nice list of reasons to redact or not redact confidential information. We'll see how that gets played out in practice. I think it will take us a little trial and error to get there. But I'm hoping that in essence, we will not need to talk about transparency or about publication processes or about redactions, because it will be second nature to us in, I think, a very short period of time.
Tremendous. We're going to move to mediation, which has been enthusiastically received, I think, every time ICSID has done a presentation. But the second question that always comes up is, will parties really mediate when push comes to shove? So the question I wanted to pose in particular to Susan and to Dawn is, will governments in particular want to mediate, and how do we go from a set of rules to mediation in practice?
Thanks, Meg. I do agree that it's been enthusiastically received in theory, because it's easy to like a process that you aren't necessarily participating in that moment. And as Meg knows, I've been working on these issues since 2007. So again, this is Ian's comment about becoming part of history is perhaps why I'm particularly interested in history at the moment. But it's really been a challenge to get people to think proactively and constructively about conflict prevention and dispute management more systematically. That having been said, on the context of mediation, some of my own preliminary analyses that are coming out of the data I collected in Scotland in connection with ICA suggest that perhaps mediation is happening already more than we might think. So people are identifying that they're acting as mediators in cases, which means there have to be cases that are getting mediated. So it's a bit like, as Gonzalo was kind enough to remind me, the Encanto musical and the song We don't talk about Bruno. No, no, no. So it's happening, but we're not talking about it. I apologize for singing at the World Bank. But I think that the bigger point is it's there. And what we need to do is raise it up to the surface and create an opportunity for people to understand the success stories of what's going on. So again, to provide a bit of a frame, back in 2013, at the American Society of International Law, you can go look at the proceedings to find this. Anna Jobin, Brett, and I put together a mediation mock and presented that to the group. And plenty of people said, now I can see what is possible. We actually had a MENA arbitrator come, not MENA arbitrator, but a diplomat from a MENA state come up to us and say, yes, we had been trying to mediate, but we didn't have any toolkit to work with. So to the extent that, for example, there is now the IBA rules on mediation for investor state disputes. There are a whole bunch of mediation training protocols that Frauke is helping to create and make sure comes to fruition. There are also opportunities for, ICSID's rules to now be in effect. I mean, this in a way, it's a creation of a brand new facility. And I think Meg is quite right to say people aren't focusing enough on what the additional facility now offers. It's not just the kind of almost open door policy for all investment disputes that's there. That's really stunning. I kind of wonder what Brokus would think about all of this. Maybe you'd be very excited. You'd also go like, how did she manage that one? But then there's this addition, and a much needed addition, of mediation, because conciliation in the ICSID sense is basically non-binding arbitration. Why would you spend $12 million on something that's not enforceable? I couldn't justify that as an investor. I couldn't justify that as a state. I could only justify that as someone who wanted to, have a billing partner prestige within a law firm. This is the partner. The problem could be us. And I do understand that, having worked in the private sector, but I want to help us think constructively about how can we use alternative methodologies like mediation, which are in a way, Meg, the rules still are actually quite loose. The mediation can be what you want it to be. I mean, there are different types of mediation. There's facilitative mediation, there's evaluative mediation, there are large issue mediations, there are small issue mediations. So to the extent that states want to use sovereignty to control the outcomes of cases and not necessarily be stuck paying a bill, there are opportunities, and this is part of that. We need to give them the success stories and start to sing about what is actually possible. We need to let people know you could decide to carve out a small part of this dispute and maybe resolve something and get some good political press for yourself. That's not out of bounds. And in fact, you can get creative options that don't involve monetary damages, right? Even the Spain solar cases are interesting, and similar things were happening in Argentina. People were creating regulatory regime change as part of the negotiation process to make sure domestic political priorities were adhered to while still managing the underlying dispute. To say nothing of one of my personal, and Antonio and I have talked about this case, but it is kind of a very funny case. The Lemire versus Ukraine case, the very first one, resulted in a settlement agreement. And the agreement there had nothing to do with money per se. He wanted the opportunity to open up a new Oksana Bayul hairdressing shop, right? So this was a kind of a very unusual remedy that an investor who'd been seeking money was able to say, no, I want something else that's about my business opportunities. And it's those kind of stories about how can you use the process to give you what you need to imagine that it is possible. The more we have the success stories, the more I think we'll create the capacity to make it happen. But we've also got to have the checklists and the capacity, lest we overpromise and underdeliver. So I think that's really where the challenge is going to be. Having the mediators who understand the unique and very different skill set required from an adjudication to a mediation. That is not insubstantial. And likewise, the mediators with those skills need to understand public international law and business. That has to be both of those working hand in hand. And then hopefully we can train all the lawyers so that you can understand all the revenue you can generate from mediation advocacy, because that, I think, is going to be a huge part of the future.
Thanks, Susan. I'm going to pass to Dawn. Dawn, we're not requiring you to sing, but we would be glad for your thoughts on mediation, and will it be adopted in practice?
Well, I certainly wasn't planning to sing, although I did admire Susan's singing. I was actually going to come at this by looking at an example of a conciliation, which in some senses, there may be, sometimes they're seen as different, sometimes they're seen as indistinguishable. But I give an example of a mediation that occurred that I was involved in. And that may help, as Susan says, tell how this can happen and why it might be useful. Conciliation, like mediation, has had a long and venerable history of being included in dispute settlement provisions and treaties, and a long but less venerable history of practically no use of conciliation. And author of the leading work on international conciliation, Jean-Pierre Cot, he once wrote that states include conciliation not because they plan to use it, because they want to show that they're committed to dispute settlement without ever planning to use it. But the example I want to refer to was a recent example under the compulsory conciliation provisions of the Law of the Sea Treaty between Timor-Leste and Australia. I think it's instructive about the use of conciliation, or the process, whether you call it conciliation, because some might say this was had more of a character of mediation. But Timor-Leste invoked the conciliation provisions of the Law of the Sea Treaty because they couldn't get Australia to agree on the delimitation of the maritime boundary between them and the Timor Sea. And I think there are a number of things you can learn from this. First, it is that the process involved allowing the parties who'd been unable to resolve their dispute and had often developed a hostile relationship to talk to each other through a third party. And for most of the Timor-Leste conciliation, until we were almost at an agreement, we met with the parties separately. So they could speak frankly about their positions, their interests, and where they could see the possibility of a solution. They couldn't do this in the presence of each other. And it was also agreed at the outset that nothing was agreed until everything was agreed. Second, although the issue was drawing a maritime boundary, Timor-Leste's real interest was access to resources which a boundary line would divide. And Australia was also interested in resources, but it wanted to preserve an agreement on the continental shelf that it had entered into with Indonesia in 1972 in adjacent areas. It didn't want to agree on a boundary with Timor-Leste that would encourage Indonesia to abandon the 1972 line. So the issue could be broadened to include related issues that reflected the real interests of the parties. And Susan's example of it turns out that the investor really wanted something else other than money, I think was a good example of provides another example of that. Third, there were related issues over which there was litigation between the parties. And once the parties became invested in the process, they agreed to withdraw from that litigation to create an atmosphere that was conducive to reaching an agreement. Now, let's get rid of the side issues that are part of your difficulty with dealing with each other and were impediment to reaching a dispute. And fourth, and this is where I think conciliation is different from what Susan describes, the legal positions of the parties were important as background of the dispute. And they had to be understood by the Conciliation Commission. But after that, they were off the table. They were always in the background. They weren't the subject of debate. It wasn't a form of arbitration under the name of conciliation. Simply, the legal position of the parties was simply not going to be determinative of the outcome. And finally, the two countries actually had a long relationship, which in the past, going back to the Second World War and earlier, was very close. It was very fractious during the period when Timor-Leste was seeking to gain its independence from Indonesia at that time, because it got its independence from Portugal and then immediately was invaded by Indonesia. And there was a long guerrilla warfare. And during that period of time, it was fractious. I don't think Timor-Leste saw Australia as being particularly helpful. But then after the Timor-Leste's independence, it became close again. And I think both parties understood that they had a long-term relationship and that getting rid of this major irritant was an important part of being able to continue their relationship. Now, it obviously is peculiar to them, but the fact they had this relationship made it easier for them to see that the long term was more important than the shorter term. Now, obviously, not all these considerations are relevant to an investment dispute or mediation or conciliation, but I think that they give insight into possibilities that can be investigated by states and investors who want to avoid a lengthy process. It took about 18 months for the conciliation here. Want to avoid the filing of lengthy pleadings by parties. The process was quite informal. There were no formal submissions. Of course, this is difficult, and I think Susan hinted at this. How do you get lawyers whose life is litigation to work in a different system, work in a system where they're not expected to write lengthy pleadings, where they're not expected to simply reiterate and articulate the position of one side, but to try and work on how to get a solution between them. And in the end, what it provided was a solution that both parties decided they could live with, and not one where one party lost and the other party won. So I think that there is an option that's worthy of consideration, and I think states are not going to be automatically willing to jump to this because they're not used to it. But if they look at it closely, they may see there are advantages that are worth considering for the longer term. Thank you.
Thanks, Don. That's really useful. I wanted to move now to the environment. And I guess we all know, for example, Venezuela, Bolivia, and Ecuador left ICSID in the mid-2000s. In 2021, Ecuador rejoined ICSID. We've seen the USMCA, where Canada and the United States excluded investor state. And we've recently heard a discussion under the Energy Charter Treaty modernization, where a number of states are saying they won't ratify that treaty, and in fact are thinking about going back and not continuing under the existing treaty and addressing the tail provisions in that treaty. So we see that direction. At the same time, we see a number of new multilateral treaties, RCEP, CPTPP. We see a number of model BITs, which are, of course, the template for negotiation. I think at last count, more than 65 states have model BITs and are negotiating agreements. And I wanted to ask, first of all, Marin and Antonio, how do you rationalize those two very different things? States leaving, but states actually endorsing and increasing use of the system. How do you rationalize the two of those trends, or is there a unifying explanation? Marin, would you start us off?
Well, it's always fun to search for unifying explanations, but I'm going to actually posit that there isn't one, because I'm not sure that there's a trend, right? I think there is a temptation, and maybe it's our current 24-hour-a-day news cycle or something of the sort that has us looking for news and what's new and what just happened and what might be happening tomorrow, and then maybe extrapolating trends out of the news. But that's not quite the same as actually looking at what states are doing, right? I think it's more important to look at the sort of how they vote with their feet. And to that end, I think when we look at states who have in the past or at the moment are talking about departing the system or departing particular treaties, I think my hypothesis is that it's more often event-driven, right? Or that there's something specific about that situation that is causing, at that moment, those states to make the decisions that they make, as opposed to saying that there's a broad swing in one direction or a broad swing in the other direction and calling that a trend. It's more fun to call it a trend. You can do a blog post about calling it a trend. But my hypothesis is going to be that we're talking more about event-driven activity here. And so, I think the poster child for that is the USMCA. I continue to believe that the ISDS provisions of USMCA are a one-time event. I could be wrong. We'll see. But I think there were a lot of political calculations, and I think probably the more significant political calculation is not the United States and Canada deciding why bother for our relationship, but the fact that the United States and Mexico still have investor-state dispute settlement in a peculiar and funny-looking form, but there wasn't a thought. The end result was not let's abandon this for all purposes. It was let's tailor make it for our specific circumstances, And I'll go out on a limb and say that with the Energy Charter Treaty, I think that's much more about the intra-EU bit impulse than it is about the system writ large. And I think the best evidence of sort of the voting with your feet is the fact that the treaty texts themselves and all but a handful of states are still playing in this system and still talking about refining it, revising it, reforming it, improving it. Very few have actually decided to set fire to it. So I don't want us to get carried away looking for trends when I think we might be making trends out of news and one-off events. So,
Thank you. Antonio, what are your thoughts?
I couldn't agree more with what Maureen says, and she says it in a much more sophisticated and helpful way than I would or could rather. But for myself, and I don't want to sound complacent, I don't think anybody is leaving the system, if by that we mean quitting altogether participation in the ISDS system. Of the 3 countries that have denounced the ICSID convention, ICSID, of course, is now back in the ICSID fold. Venezuela and Bolivia seem to continue to participate actively, if not at ICSID, then another ISDS fora. So according to UNCTAD's ISDS Navigator, 22 ISDS cases have been brought against Venezuela since it denounced the ICSID convention, about 2/3 as many as before that time. And as for Bolivia, many more cases, 16 in total, have been initiated involving it since the country denounced the ICSID convention, when just 3 cases had been brought against Bolivia. I think it's important in this discussion to remember the consensual character of the ICSID system, as emphasized by the report of the World Bank executive directors on the convention. No country is obligated to become, or we might add, remain a party to the ICSID convention, or being a party to make use of the dispute settlement facilities of the center. Nobody, I think, would characterize as having left ICSID a party that decided, for whatever reasons, against submitting investment disputes to the center. If nothing else, its nationals would, as long as their state remains a party to the ICSID convention, continue to be eligible themselves to use the procedures of the convention for their disputes with other parties to the ICSID convention. So there you have participation in the system at least at a very close remove by the country concerned. Once there are no more cases brought by EU claimants against EU respondents, there should still remain a large proportion of cases involving EU nationals against non-EU countries. I looking at the ICSID caseload database. I mean, I may have gotten my sums wrong, but I calculate from that 20% of all ICSID convention and additional facility arbitrations involve as claimants EU nationals and as respondents non-EU states. So in this post-ACNAS scenario, you still have quite heavy participation in the ICSID system on the part of European parties. And similarly, again, based on pending case levels, it would seem, if they're sustained, of course, it would seem that about 10% of the cases would continue to be brought by Canadian and US nationals outside of the USMC area. Thank you.
Thank you. I recognize we are low on time, but we just want to go to two quick questions on the future. The first, Antonio, will stay with you, is ICSID has an amendment formula under the convention requiring 100% approval of member states. Is that going to be a barrier in the future to continued modernization?
Well, in the spirit of cutting short the time I spend in my remarks, I would simply answer that question by saying no. It's true that amending the convention requires ratification by all ICSID contracting states of the amendment. And there are 158 of them, and ratification processes are commonly very lengthy. So at a minimum, this would, amending the convention itself would be a problematic endeavor indeed, I would think. But on the other hand, amending the regulations and rules of applicable to convention proceedings is comparatively easy, requiring only a 2/3 majority vote of the members of the Administrative Council, so long, of course, as the regulations and rules remain consistent with the mostly flexible and broad provisions of the ICSID Convention. So a main avenue for reform at ICSID has been amendment of the ICSID regulations and rules, and this has been demonstrated by successive amendments of the regulations and rules, including most notably the, in several respects, far-reaching amendments recently adopted by the Administrative Council of ICSID in March of this year. Among the new amendments, changes of the ICSID arbitration rules regarding the publication of awards and the procedure for deciding challenges are particularly striking for me in this respect. Article 48 of the ICSID Convention forbids ICSID from publishing an award without the consent of the parties. And in accordance with Article 58 of the Convention, in the typical case of a 3-member arbitral tribunal, the challenge of one of the arbitrators is decided by the 2 others, unless they're equally divided, in which case the challenge is decided by the president of the World Bank in his capacity as chairman of the ICSID Administrative Council. As for the publication of awards, newly amended ICSID Arbitration Rule 62 deems the parties to have given their consent to the publication of the award by ICSID if neither objects within a certain period after dispatch of the document. And as Marin noted not too long ago, this really, ICSID has shown its ability and willingness to push the envelope as far as it possibly could in this respect, and I think very successfully, without, of course, entering into an amendment of the ICSID Convention. And in regard to the procedure of having the possible disqualification of a member of an arbitral tribunal, normally determined by his or her colleagues on the tribunal, this procedure termed as unsatisfactory, end quote, by an ad hoc committee chaired, I think, by Professor McRae in a recent ICSID case. In respect of this procedure, newly amended ICSID Arbitration Rule 25 provides that if, in the event of a challenge of one of the 3 arbitrators, the 2 others are unable to decide the challenge for any reason, they will be deemed to be equally divided, with the result that the challenge will be decided by the chair of the Administrative Council. And these examples show, I think, how much can be achieved in the way of constructive change by amendment of the regulations and rules of ICSID while remaining within an unchanging framework of the ICSID Convention. Looking ahead, to bring up a hobby horse of mine, one might imagine a future amendment of the ICSID arbitration rules, modernizing the standard for disqualifying arbitrators for lack of impartiality and independence, in much the same way as this has already been done in the newly amended ICSID additional facility arbitration rules. Perhaps the toughest future challenge for ICSID will be the creation of an ICSID appeals facility if contracting states decide, after 18 years, I might add, that they would now be ready to entertain this idea. In one sense, however, in the limited sense of approving a set of additional facility rules, like those mooted by ICSID in 2004, the task may actually be even easier than amending the ICSID regulations and rules, because under the convention, adoption under such an entirely new set of rules would require only a simple majority vote of the Administrative Council members. But putting in place the more substantive adjustments that would underlie such additional facility rules would be daunting, possibly involving inter se modifications of the ICSID Convention by inter-SID contracting states, as envisaged in Article 41 of the Vienna Convention on the Law of Treaties. But I hasten to add that even this may not be beyond reach if such a facility is desired by significant numbers of contracting states. And we also shouldn't forget another plea I make, but often find that it doesn't resonate with many people, that an appeals facility might more readily be installed if it were to be made available for provisional rather than final ICSID awards, as in fact is done without a lot of highlighting, but it is done for appeals under the investment court system of some of the EU investment treaties. So all in all, I'm very optimistic as usual. Thank you.
Jose, if we can just have a quick answer and we can finish up on appellate body, which has already been raised.
Yeah, absolutely. Very quickly, I fully agree. I mean, I couldn't agree more with Antonio. But I'll just make one remark, which is where do we come from? And when I teach, one of the introductory remarks that I share with students is the ICSID system is still today revolutionary and brilliant. It's one of the few international economic systems that allows right of recourse internationally. So that's the framework. Within that framework, yes, there might be difficulty in changing the convention, almost impossible, but the amendments and the series of amendments that we have seen is sufficient proof that amendments can be done. The examples on transparency were a few examples that were given. Another example is, for instance, how the new Rule 41 clarifying that it's not only related to manifestly lack of legal merit, but manifestly lack of legal merit also involves or could involve issues of jurisdiction. So when I see how the ICSID Secretariat, but also the international investor state arbitration community interacts one image, came about a few weeks ago, and made me think a little bit about the notion of progressive development and codification entrusted to the ILC of the United Nations. That is an explicit function that body has, but in many respects, that idea of not throwing everything or setting everything on fire, but actually calibrating, reviewing, codifying some of the rules that tribunals provide is part of what we have seen. And that's why I'm also very hopeful, and with change within the system that will make the system better, not doing away with it.
Thank you. We're going to finish with one question, which has been prefaced here. The whole question of a multilateral investment court or appellate body. Are there further adjustments to the ICSID system that might better address the concerns that motivate that? And could ICSID, for example, play a role in such a body if states decide that that's the direction they wanted to go in? And Don, I wonder if you could start us off on this.
Yes, thank you, Meg. I think one has to be cautious about thinking one could move to an appellate process with just an adjustment to the existing system. In other words, one might think of taking the annulment process and expanding the jurisdiction. But I think that if you're going to have an appellate process that's going to provide consistency and predictability by giving common interpretations to provisions that are common throughout a variety of investment treaties, I don't think an ad hoc process like that is really going to work. And I think the experience of the WTO is useful here. WTO established an appellate body, and what did they do? They gave them 4-year with once renewable terms. The first appellate body was composed of people with expertise in international trade law, expertise in public international law, expertise in dispute settlement. And they had credibility, I think, although states didn't necessarily like every decision they made. They had credibility because they had the authority of their knowledge and the way they wrote their opinions. What has happened over time is that the expertise in trade law, while some have it, is not so widespread. The expertise in public international law is not so common, and background in dispute settlement is not common. And so what you had was, as the diminishing authority of the appellate body progressed, the Secretariat played a more and more major role, so that it became as if essentially the decision-making was becoming rigid, and it was perceived that the Secretariat was heavily involved in decision-making and the appellate body members not. So what we learned from that? We learn, I think, first, that in order to have a body that will be credible in interpreting the treaties, you've got to have individuals who have expertise. You've got to have people who have individuals who have expertise in investment law, individuals with experience in treaty interpretation, and individuals who are experienced in running arbitrations. If you don't have those people on that body, then you're going to have the same problem emerging as happened in the WTO with reliance on a Secretariat. And that means you have to have people with much longer terms than a short 4-year renewable. You've got to have people with terms where they can create sufficient credibility over time, and the confidence of the parties in letting the system operate for that period of time rather than changing after 4 years if parties don't like individual members of the appellate body not renewing their terms, not accepting them for a second term. So a 4-year term is not really consistent with the long-term credibility of an appellate body. Finally, I'd say that a body with experience, expertise, and longer terms will have the necessary authority to manage a Secretariat. And when the Secretariat has greater expertise than the individuals who are deciding the cases, you can see what is likely to occur. And that's something that would have to be avoided in an appellate process. It could be housed in ICSID. ICSID could manage an appellate process with independence to a Secretariat, but it would have to be people with long-term, much longer term, and much greater expertise than simply asking to people to take on this role because they'd be politically acceptable, but rather than looking at the real expertise that you need. Thank you.
Thank you. Susan, do you want to close out the session?
I think that I'm happy to do that. And part of the reason I would like to is Antonio has been working on these issues since 2004. And I remember when I was a young associate dealing with the two Lauder cases and thinking back in 2001, 2002, what do we do with some of the challenges and the creation of consistency if we need it. But Antonio was one of the people who led the charge. And as you said, Meg, there's that paper from 2006 that still is available. And it was also a time period when the US Department of State was working to create opportunities for people to consider appellate bodies. And I am now in this vein of history, once again, old enough to remember when European governments told me that I was ridiculous for purporting to suggest an appellate body might be useful. Just keep that in mind. 20 years ago, they laughed at me and I was taken aside in conferences and strongly encouraged to do more useful scholarship. Now, that having been said, part of what I want to make sure people hear is the political winds shift. And for my money, the only thing that makes the most sense to me is ICSID must be involved in any conversation related to an appellate body, lest international rule of law work at cross purposes rather than in harmony.
Thank you. That's a tremendous end. I want to thank all of our panelists who brought a lot of expertise and really good thoughts to a diverse range of topics. And I want to thank all of you who are here, both in person and remotely, and wish you a very good rest of your Washington Arbitration Week. So this will close the proceedings for today. Thank you.